Good day, Crime Talk aficionados. We have a great show for you heading into the weekend. First, Lori Vallow learns being your own defense attorney is tough. Jennifer Crumbley may actually get a new trial, which I agree with. Put down the TikTok while you're driving. You better be more supportive of your significant other. Your life could depend upon it. Cops get called out, and they don't like snitches, apparently. And we all know what happens to snitches, right? Let's do some legal geeking out about geo-fencing warrants that's up at the federal appellate courts. Old-time criminals loot the treasury and enrich their friends. Let me give you an example. Tell me I'm wrong. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And you can check us out on any of your favorite podcasting apps as well. Now, before we get to the docket, go to crimetalksearch.com, sign up for that background subscription service today, and when you do, you'll be able to do as many background searches on anyone here in the United States that you desire. Anyone. And you're going to find out all types of information about this individual, stuff that you may not even want to know, but you're going to find out about it. Do they have a criminal history? Are they married? Are they divorced? Do they have judgments against them? Do they, for example, have 20 different email addresses that they didn't tell you about? What do you need all those for? Is that because those are all your dating apps? Check it out. CrimeTalkSearch.com. You're going to be happy you did. And hey, you may be surprised as well. All right, let's go ahead and open the record for January 31st, 2025. And first on the docket is Lori Vallow. That's right. She wanted to be her own judge in her case currently pending in, Arizona, because after all, she's been through a trial in Idaho. And how tough was that, right? I mean, she got convicted of 3 counts of murder, going to spend the rest of her life in prison. Then she's got this little nuisance case down in Arizona for the death of her former husband, Charles Vallow, as well as the potential shooting of her niece's husband, right? She doesn't like her attorneys. They want to raise competency. They want to, mess with her speedy trial rights. And she says, no, I've got this. So she's filed a couple of motions. As you may recall, one of the first motions was she wanted all the information about why she was being extradited to Arizona, because she had this case in Idaho and they weren't going to extradite her. And then they did. So she somehow thinks that they can't do that. Anyway, that's denied as well. Then she files a motion for speedy trial, basically saying that her speedy trial rights have been violated and therefore, as a matter of law, the matter should be dismissed. Well, guess what? Today, a judge in Arizona has denied her motion to have her cases dismissed. Shocking, isn't it? Anyway, Lori Vallow, who is already, like I said, serving multiple sentences for convictions in Idaho, is facing 2 separate charges for conspiracy to commit first-degree murder in Arizona. Now, this specific case is connected to the attempted murder of her niece's ex-husband, Brandon Boudreaux. Like I said, representing herself, Lori Vallow argued that her case should be dismissed due to not being granted a speedy trial. The judge disagreed and said, hey, there have been delays, but those delays have been justified. Consequently, the trials are expected to proceed back to back. And Lori Vallow, like I said, who was previously convicted of killing her 2 children and her most recent husband's wife, this is just icing on the cake for her, I guess. I don't know. Now she gets to play her own lawyer, and she's finding out that it is a little more difficult than she thought it was. Obviously, right? I want a trial within 6 months. Therefore, if I don't get a trial within 6 months, the case is dismissed. Or if it's declared complex, I think it's 9 months. The first thing they teach you in law school, Ms. Vallow, is although the rule is this, the general rule, there's always an exception. And I assure you, one of the things that judges always worry about is making sure that the speedy trial rights are not violated. I can tell you, I can probably count on one finger the cases that I have seen that have actually been dismissed on speedy trial grounds, because the state will oblige you, and the judge who's ultimately responsible for that is keeping close eye on speedy trial. So is the district attorney, as well the defense should be. But I'm telling you, they usually require a waiver of speedy trial for any continuance requested by the defense. And therefore, well, motion to dismiss denied. Next on the docket, Miss Crumbley. That's right, Jennifer Crumbley. She may get a new trial. And it's not the unique legal theories the prosecution proceeded upon. It's probably for prosecutorial misconduct. Ooh, don't you hate when that happens? That's right. Up there in Michigan, an Oakland County judge denied the request from Jennifer Crumbley to have her basically acquitted or given a new trial in connection with the Oxford High School shooting. Now, Crumbley, the mother of the shooter, was found guilty of 4 counts of involuntary manslaughter last year, which is completely ridiculous. And I get it. It's a school shooting. Everybody should be upset and appalled, and we want justice and we want accountability. But the theory in which she was convicted, completely wrong. Anyway, her husband, James Crumbley, was also convicted of the same charges, and they were each sentenced to 10 to 15 years in prison. Anyway, the judge did not make a decision on whether Ms. Crumbley should get a new trial based upon a proffer agreement the prosecution made with 2 witnesses in the case. So this is where it gets interesting. The Oakland County prosecutor, a woman by the name of Karen McDonald, and the prosecution team gave proffer agreements to the Oxford High School counselor, Sean Hopkins, and the former dean of students, a guy by the name of Nicholas Ejak, E-J-A-K. And according to the statements provided to the prosecutors, they could not be used, anything that they said could not be used against them. And according to the agreement, anything that the 2 individuals said to the prosecutors could not be used against them. It's basically immunity. And they were the last administrators to meet with the school shooter before his rampage there at the school. Anyway, in its agreement between the prosecutor's office and the individual that whatever they say, as long as they were truthful, i.e. sticking with their story, they will not have those statements used against them. Anyway, the defense team says Jennifer's defense attorneys claim that they were never given those agreements to the first defense attorney who handled the case. Remember, Shannon Smith was her name. Anyway, on Friday, the judge heard argument over the proffer agreement and during the motions hearing. And so the judge has to decide on that. She rejected everything else they had, but now the issue is this exculpatory information? Okay, so my humble opinion is she should probably get a new trial based upon that in and of itself. Okay, the fact that you have witnesses testifying at a trial that were basically given grants of immunity, right? They're not being prosecuted. They're in the same room with the parents who are being prosecuted, and they get a free pass. How is that not completely ripe for cross-examination? Any defense attorney, even just out of law school, could probably come up with at least 40 to 50 questions on, why aren't you being charged? You were there too. You didn't do anything. You didn't call the police. You had a good faith belief that this person was going to go do something. According to the prosecution's theory, my client knew it, so therefore you had to have known it, but yet you were not being prosecuted. Like I said, that's the general rule, right? Prosecution doesn't turn over exculpatory information. You would think that she should get a new trial. Ms. Crumbley should get a new trial. But let me give you a case. It was a 35C case that I handled years and years ago. The client was a young kid, and they robbed somebody for a Denver Broncos jacket, and the victim got shot and died. And they were all charged with felony murder because the kids were in the process of an aggravated robbery and somebody died. Easy enough, right? Anyway, one of the co-defendants testified saying that the other young Utes of America were the real bad guys, and he was just along for the ride. That kind of deal. Anyway, that kid takes a deal for like 48 years. Comes along, literally 20 years later, I get the case from when the case happened. I do the 35C. We find out that there was an agreement between the prosecution and the defense for that testifying witness. After 16 years, the sentence would be reconsidered. None of that was turned over to any of the defense attorneys at the time. In fact, it was tucked away neatly in a court file that nobody ever saw. And this is before all the electronic filings of things that took place. And it would never have been found but for the client's dad had gone to just pull the file, and it came up. And we went to hearing and, had everybody testify. It wasn't there, wasn't produced, wasn't disclosed at trial. And the judge said, well, what's the harm? What's the no harm, no foul? I don't know, ladies and gentlemen. I'd give Crumbley a new trial based upon that. Who knows? She'll probably lose again, but I think the jury should know that the people who are in the school, the government employees, somehow get a pass. But they want to test out this new theory. Why not test it out on everybody? Isn't that the way the law is supposed to be applied? Next on the docket, get off your damn phone. Better yet, get a Faraday bag. Get a Faraday bag to put your phone in while you're driving. 1, you can't use it. 2, it's not tracking what you're doing. Please meet Mariska Nunn. She's been charged with criminal felony vehicular homicide after an incident that took place back in September of 2024. She was booked into jail, but now she's been charged by the Becker County Sheriff's Office. Now, apparently, Nunn's cell phone data, what does Scott always say about that cell phone data? Anyway, Miss Nunn's cell phone data revealed that she was using the TikTok app in the minutes before her car hit and struck an 81-year-old man by the name of Dean Chadbourne, who was just simply walking on the side of the road. Apparently, Miss Nunn was driving on this road in Detroit Lakes, Minnesota, at about the same time on September 3rd on her way to her boyfriend's house. She did tell the police at the time that she did not see Mr. Chadbourne, who was, like I said, walking on the side of the road, and she initially told police that her phone was in her lap when she hit Mr. Chadbourne. Later on, she admitted that she was actually watching a TikTok video, and included in the criminal complaint was a rundown of the cell phone data in the minutes leading up to the moments that Miss Nunn's car hit Mr. Chadbourne. According to the report, Miss Nunn was using TikTok that afternoon at 12:08 and 40 seconds, and then again at 12:10, 50, 12:12, 40, 12:12, 52, and 12:14:05. Coincidentally, she called 911 to report the crash at 12:15. Anyway, her next court date is February 20th. Needless to say, Mr. Chadbourne was transported by ambulance from the scene, but unfortunately passed away. Put your phone down, ladies and gentlemen. Be more focused on driving. It's dangerous out there, and it could get you charged with that phone. What do I keep telling everybody about the phone? I mean, the only thing you should probably do is you want to get one of those little CrimeTalk stickers right there. Put it on your phone. Right? It will remind you. What are you going to say if you get in trouble? Lawyer, lawyer, lawyer. Just something to think about. Next, you should probably be more supportive of your significant other. I mean, who knows? Your life could depend upon it, right? Listen to this. So a 29-year-old woman here in Colorado is going to get to learn her fate in several weeks and find out how many decades she is behind bars for killing her boyfriend, shooting him twice in the head shortly after she attempted but failed to drown and burn his cat. All right, this was a 3-week trial just out here in Adams County, Colorado. And it's a 20-minute drive from my office here. I was out there earlier this week. I should have poked my head in. Anyway, jury found Ashley White guilty of 1 count of second-degree murder, conspiracy to commit second-degree murder, and robbery going back to this 2020 shooting. So apparently Miss White and Delisa's relationship had grown volatile. That was the boyfriend's name. Last name is Delisa. Anyway, their relationship had become volatile and strained in the months preceding the murder, when the victim often criticized Miss White for struggling to secure full-time employment. White apparently expressed some resentment, even writing in her diary that she regretted ever meeting Mr. Delisa, and her frustrations escalated after an incident in which she attempted to drown and burn Mr. Delisa's cat. Needless to say, that raised some alarms. Anyway, the couple's relationship continued to struggle and got pretty bad on August 13th of 2020 when White went for a job interview in Denver. A neighbor drove her to the interview and she took the bus home. And during the trip back on the bus, Miss White texted Delisa about the interview, and he responded by expressing skepticism about her chances of getting the job. which needless to say upset Miss White. But while on the ride back, White meets a nice young man who'd introduced himself by the name of Scott. Where was I back in August of 2020? Not on the bus, I assure you of that. Anyway, these two began talking. At some point, Scott asked Miss White if she was in a relationship with a man and whether he raped her. White responded that he had, in fact, done that. And Scott then said, well, by God, we must kill him. The two apparently got off the bus and spent time together and fired Scott's gun. They then walked to White and Delisa's home, where Scott introduced himself to Mr. Delisa as White's brother, claiming that he was from Texas. But within minutes of the false introduction, White and Scott shot Delisa twice in the head, obviously killing him. They then took Mr. Delisa's wallet and fled the scene. Well, after the murder investigation, White and Scott spent the next few days in the area before Scott departed, and Miss White apparently never saw him again, according to prosecutors and various witnesses. Anyway, Delisa's body was discovered when police conducted a welfare check at the home a day after the shooting. Needless to say, investigators quickly identified White as the primary suspect in the shooting, and she provided a detailed confession during the interview with detectives, which ultimately got her arrested. It's always the defendant's own words that get you. Anyway, the identity of the Scott guy remained a mystery for about 3 years, which is when a woman contacted the district attorney's office saying that she believed her boyfriend, a guy by the name of Michael Stratton, was the other person responsible for Mr. Delisa's murder. At the time, Stratton was already in custody for yet another murder for a guy by the name of Michael Hunt down in Pueblo, Colorado. Prosecutors say that Stratton has been deemed incompetent to stand trial for Mr. Hunt's murder and has not yet been charged in the killing of Mr. Delisa. So Miss White, Miss White, the woman who believed the man that she just met on the bus that her boyfriend should be killed, she went to trial and lost, as I noted, and now she will be sentenced on April 4th. She faces up to 48 years on the murder charge. So, rule of thumb, ladies and gentlemen, once again, I got to start this app. Is this a good decision, right? It could be like a quick text me thing. I met a man on the bus. He said I should kill my boyfriend. Is this a good idea? And I would say no, right? I would talk you out of that. And then it turns out the crazy man that you meet on the bus with the crazy ideas turns out to be freaking crazy. Miss White, what were you thinking? Unbelievable. Unbelievable. All right, next on the docket. Cops get snitched on and they don't like it. And we all know what happens to snitches, right? Snitches end up in ditches. Snitches end up with stitches, right? That's what the cops were maybe trying to do. Maybe put a little intimidation on this guy. Listen to this. So a Texas police union official jokingly called out a tattling driver who took a video and posted it of police officers doing donuts in a parking lot down in Houston, Texas, because there was a big snowstorm, right? Who hasn't done this where you were a kid and it snowed? It's fun. But needless to say, things escalated rather quickly. So Hammond Brown put on his Facebook post a video identifying a Houston police officer doing cookies and donuts in the police car in an attempt to have some fun. Anyway, Mr. Brown posted the video, and it didn't go viral, but it got, I think, 5,000 views or something like that. Anyway, he put on his post, man, look at the Houston PD here. They out here doing donuts, man. They got nothing else better to do. And then it started. So after Brown made the post, the Houston Police Officers Union fired back and pointed out Brown's traffic infraction during the video. That's right. Brown's windshield was sporting a rather large multi-arm crack covered in tape. Oh, yes, the old smear, silence, destroy tactic, huh? Yeah. Anyway, the police continued saying, tag local auto glass repair companies. We're looking for someone who can help Hammond Brown get his broken windshield repaired. Well, because apparently in Texas, you could face fines if the crack in the windshield is larger than 3 inches. Very nice of the police officers to point that out. It's probably also legal to do cookies now, isn't it? Anyway, the union says they were just joking and said Mr. Brown needed help for paying for the repair since he didn't earn money reporting the cops on a snow day and their little cookies or donuts. Anyway, they said exactly, he didn't get any Crime Stoppers money for snitching, tattling, so we need a good sponsor that can hook him up. Now, the union president defended the officer's actions as a stress reliever while serving a very stressful career. I'm going to use that as a defense when I'm out doing cookies next time it snows here in Denver. Anyway, the police union said, hey, we're human. We like to have a good time just like everybody else. Anyway, Griffith thought the banter was all in good fun, but things went, like I said, a little south. After the video, the union's reaction went viral. Brown held a press conference and said he didn't appreciate the union making his life events public, adding that he didn't want no problems. The union returned shared the news clip. Never post anything on the internet you don't want to see on the news or the internet, the Post said. Anyway, the union found the footage posted by Brown of him hopping out of a moving car on a busy street and climbing onto the windshield, where he began to ghost ride on the vehicle. Anyway, Brown performed the dangerous stunt as an ambulance raced by down the road with its lights and sirens on. Remember Heyman Brown, the hater that went on the news to run his mouth about police cars in the snow? Yeah, don't be a hater. Coming, dying, gotta get them, the union put on their latest post. Anyway, Griffith called out Brown's hypocrisy, saying people can't do the stunts he does and then turn around and call out others. The union boss also added that the posts were all just good fun, but Mr. Brown wasn't feeling the love. He said, they're really messing with me right there. They're posting my business on social media, and it's got him scared. He didn't do anything wrong. Anyway, he alluded to the officer's misconduct being addressed and should be taken care of. Anyway, ladies and gentlemen, sometimes it's better just to leave well enough alone. And I guess that's a little Facebook war that went on between Mr. Brown and the Houston PD's union representative. It's all fun and games until somebody gets called out, right? Next, let's geek out on some geo-fencing warrant arguments that are up at the federal courts. Now, why is this significant? Well, some courts have already said these are illegal, and the police use them all the time, ultimately going to wind up at the United States Supreme Court. So there was an en banc panel. What's en banc? It's a fancy word for everybody, all right? So most appellate courts usually have, say, 12 judges, but then they're divided up into 3 panels of judges, and they divide up the cases. But when there's a really big issue, they get them all together, and they use a fancy word called en banc to hear the argument in this particular case. And that's what happened. And this is up at the Fourth Circuit, and they're using a bank robbery case to debate whether geofencing warrants violate the Fourth Amendment. All right? So this argument went on for over 2 hours amongst, in this case, 15 judges, and it was a quite contentious discussion, apparently, over Google's role in law enforcement investigations. Several of the judges asked, it casts a digital dragnet that gave police discretion over what to search and see. All right? That was one of the arguments from the National Association of Criminal Defense Lawyers representing the defendant. It was like making a landlord search every unit out of a 1 million-story apartment. That was the analogy he gave. And after coming up empty in the investigation, the armed bank robbery of Call Federal Credit Union in Middleton, Virginia, detectives obtained a geofencing warrant requiring Google to scan through the 500 million users who've enabled location history tracking for suspects. Now, after limiting the search to a 150-foot radius around the bank, investigators eventually narrowed the scene to 19 individuals before further narrowing it to 3 and focusing on a guy by the name of Okello Chatrie, Chatrie. Well, Chatrie accepted a conditional guilty plea and was sentenced to 141 months in prison and 3 years of supervised release. Now, in the federal system, a conditional plea is you plead guilty, but you get to preserve your appellate issues so they can go up on appeal. Usually that doesn't take place in state court. You want to go do your issues, you got to go through trial. Anyway, so he appealed the trial court's decision to deny his motion to suppress the evidence from the geofencing search. He unsuccessfully argued to the 3-judge Fourth Circuit panel that the search violated the rights of privacy. They wrote, "We find that the government did not conduct a Fourth Amendment search when it obtained 2 hours worth of Chatry's location information since he voluntarily exposed his information to Google," one of the judges wrote. And another judge asked why Chatry would opt in to allow Google to track his location. The attorneys responded that it was not meaningfully voluntarily because the opt-in screen did not convey meaningful information about the nature of the data collected. And one of the judges says, well, everybody is not that ignorant about cell phones. In fact, the judge said that I've done it and I'm a Luddite, meaning an idiot. Anyway, the attorney pointed out that only roughly a third of Google users actually opt in. So if the bank robber was thinking bank robber, he'd leave behind no evidence, no fingerprints, no cell phone data. He just wasn't a very smart thinking criminal. Anyway, the Fourth Amendment requires law enforcement to have probable cause, and particularly when they search for a suspect, the attorneys argued. They said, quote, "The framers crafted the Fourth Amendment to protect future Americans from the invasive general warrants that plagued them during the colonial era." And the attorneys continued that geofencing warrants are a contemporary incarnation of the general warrant, and the framers reviled those particular general warrants. Another judge expressed concern that the invalidation of the warrant could have far-reaching consequences, and he asked why the court should basically let someone go free by excluding relevant evidence. Anyway, next time it's not going to be a bank robber, right? It could be a murder. It could be a terrorism attack, one of the judges noted. And their response was, "I don't think you realize how much you're taking off the table in terms of tools that law enforcement can use in the most serious of cases," the judge noted. Anyway, another judge rebutted that point by saying that this concern was the broad nature of the search. The result does not drive the means, the judge noted. If we are going to do the police's job, then let's just declare the Fourth Amendment non-existent and just say, anytime you want to search something, you just go ahead and do it. Well, another judge then piped in and asked whether he believed all geofencing warrants, including the one used to indict the suspect during the January 6, 2021 insurrection, were unconstitutional. One of the attorneys said, "I think it's impossible to get away from the initial search of millions of people," the attorneys noted. "You're searching the haystack for the needle. You can describe that needle very particularly. You can describe its shape and color, but you must still search the whole haystack to get there. Hence a general warrant, right?" Anyway, they went on and compared the data search to police investigating a crime scene. The attorneys pointed out that the police grab plenty of people's information from crime scenes without implicating them in the crime. He listed DNA, shell casing, notes, and surveillance footage as an example of broad evidence that police use to narrow down their particular suspects. The reality of a police investigation is to collect data on all kinds that are left behind at the crime scene. And when they search for that, they're not looking for individual human beings. They are looking at data, unidentifiable data. Anyway, one of the attorneys said, hey, that unlike in scenarios where investigators are looking at a specific crime scene, the first step of the geofencing warrant is Google providing millions of individuals who have opted into location tracking regarding where they are. Now, the attorneys quibbed over whether the search begins when Google opens its files or when Google applies the criteria users within 150 feet of the bank near the time of the robbery. Anyway, part of what we're dealing with here is we're dealing with judges who are confronting new technology and want to apply the most simplistic principles to it. One of the attorneys noted, it's not particularized data. It was 592 million people that they were searching. Anyway, one of the attorneys said the use of geofencing warrant is a way to reverse their way into actually investigating. No probable cause until ultimately you find something that comes of interest to you. the attorneys noted. And if we do this, we are going to be the ones who are broad in it. And the broadness is not just on Mr. Chattree in this particular case, the attorney argued. It's on every citizen who is under the Constitution of the United States. One of the justices asked whether, if the best course of action was to leave the constitutional question for another day and instead simply find that the warrant was a good faith exception to the Fourth Amendment. The Fifth Circuit recently held that geofencing warrants are unconstitutional under the Fourth Amendment. Anyway, whoever robbed the bank, Mr. Chattree, got away with nearly $200,000. And obviously this case is important because it brings into question the government's ability to track the movements of millions of Americans, and the full court here plainly appreciated the significance of the question. So let me give you a quick example of geofencing, ladies and gentlemen. Sometimes you think, wow, that's really good police work, but it is a broad general search. And under the Fourth Amendment, general searches are strictly prohibited. You can't say, back in the old days, the king would send his men over and say, we don't like you. We heard you've been saying some mean, nasty stuff about the king, so we're going to come into your house and look around. We're not sure what we're looking for, but we'll know when we see it, and then we're going to arrest you and take you to the gallows, right? General warrant. And that's what this is really saying is, hey, you're not looking at a suspect. You're looking at all of this data, and this data is out there. You don't know who it belongs to. You don't know who it is. It means nothing to you until you narrow it down. Like, here's a particular location. Let me give you an example. Had a case once, string of burglaries of businesses at night. Police had no suspects whatsoever. And so they request a geofence around the businesses during the time that they thought that they were actually being robbed. And coincidentally, the geolocation data from the Google phone put various people's phones right there. Then, of course, they go talk to the people and they say, yeah, I was there, confession. And then they implicate other people, say, yeah, they were there with me as well. So, good police work or violation of one's constitutional right? I would say tough decision. Several state courts have said it's a illegal search. We had a case here in Colorado where they did a search of searches who searched information regarding a house that was burned down and killed like 8 or 10 people. The trial court granted the motion to suppress. The Colorado Supreme Court heard the issue and said, well, kind of like what these courts are doing, we're going to find that since this was never really done before, there's a good faith exception. Yes, it was done illegally. It was a broad search. But since the police were acting in good faith, we're going to let this one go, but don't do it again. That's kind of what they're trying to do here at the Fourth Circuit. I think we need laws like, I don't know, like a HIPAA law, right? Nobody can release your medical information unless you give them permission to do so, right? It should be that way with all of the people that have their little apps on their phone. They can't give up your information unless you consent to it. Problem solved. You think Congress is going to get around to doing that? No, of course not, because too many people make too much money. And let's face it, it is a huge investigative tool for the police. I have had detectives tell me the first thing they do is always go to Facebook. Log on, see what people are putting on their Facebook. Just something to think about, ladies and gentlemen. I think privacy is going to be the new cool, if it's not already there. Next, old school politicians. They know the drill. Loot the treasury and enrich their friends. Let me give you an example. So the jury is deliberating after a federal corruption trial of an ex-Illinois House Speaker by the name of Mike Madigan. Now, before the jurors began deciding the 23 counts of racketeering, fraud, bribery, and conspiracy charges, Madigan's co-defendant and longtime ally, a guy by the name of Mike McLean, joins him on 6 of those counts. Now, federal prosecutors, a guy by the name of Amarjeet Bachu, presented them with the government's most basic accusations against the former speaker there in Illinois. Basically, he said he had the trust that was placed in him by each and every member of the public, the prosecutor argued, and said that Madigan, adding that the former speaker abused that trust. He lost his way, the prosecutor said. He was blinded by profit, by power, his desire to stay in power. Anyway, Madigan served in the Illinois House for 50 years before retiring in 2021 and led it as the Speaker for 36 years. He also served as a chair of the Democratic Party in Illinois for over 2 decades. Throughout the trial, prosecutors have painted Madigan as a political kingpin in Chicago and Springfield, the capital of Illinois, and the head of the so-called Madigan Enterprise. They claim that between 2011 and 2019, he tried to use his significant public power to funnel jobs and benefits to his allies and to direct work to his private law firm, Madigan and Getzendanner. The prosecutor said McLean, a veteran lobbyist who once also served as a Democratic state legislator, acted as Madigan's agent and bagman. Madigan and McLean both faced the overarching racketeering conspiracy charges stemming from their participation in the alleged criminal enterprise. The remaining counts stem from 5 discrete episodes, as prosecutors termed them at the start of the trial. The largest of these episodes involves Madigan's support for an energy company called ComEd and their legislative agenda in Illinois between 2011 and 2019. In exchange for ComEd arranging jobs and contracts for their allies, a major focus of the prosecution was how 5 Madigan allies, Chicago political workers Ray Nice and Ed Moody, former Chicago alderman, Frank Olivio, and Mike Zielinski, a former Democratic state representative, and Eddie Acevedo reportedly received a collective $1.3 million from ComEd for doing nothing on some alleged subcontract gigs. The subcontracts were arranged under the law and lobbying firms that contracted with the energy company and operated by Madigan's associates. McLean figures heavily in this whole alleged scheme, having worked for years as ComEd's contract lobbyist. He is one of ComEd's 4 of ComEd's lobbyists and executives who jurors convicted on separate corruption charges related to ComEd's attempts to win Madigan's favors back in May of 2023. In a similar episode, prosecutors say McLean helped AT&T Illinois arrange another do-nothing subcontract for Eddie Acevedo in April of 27, this one worth $22,000. And like ComEd's, prosecutors say AT&T sought to secure Madigan's support in the Illinois General Assembly for legislation benefiting the company. Is that how that works? Wow. Who would have thought, ladies and gentlemen? Oh, that's right. Yeah. Anyway, the 3 other episodes of the case involve a guy by the name of Danny Solis, an ex-Chicago alderman turned FBI informant. Solis served as both the alderman of a development-heavy city ward and chair of the city's zoning committee during the charged period. He began cooperating with the FBI in 2016 amid his own corruption allegations and secretly recorded multiple conversations with Madigan, McLean, and others in the case starting back in 2017. Now, prosecutors say that when Madigan began reaching out to Solis for introductions to property developers, claiming the former speaker hoped to use Solis's influential position in city government to coerce the developers into hiring Madigan's law firm for legal work. Anyway, Madigan also purportedly backed with Solis help an ultimately unsuccessful legislative 2017 effort to transfer a state-owned parking lot in Chicago's Chinatown neighborhood to city ownership. Prosecutors claim that Madigan hoped to receive legal work from potential private developers on the site had the land transfer gone through. Finally, the government claims Madigan tried in 2018 to help Solis get a state board position under the then incoming administration of Governor Pritzker. Madigan and McLean's attorneys, during their closing arguments, attacked Solis's credibility. Madigan's attorney went so far as to call him a malignant tumor at the heart of this case. You can't trust Danny Solis. You can't trust him. He has his own agenda, and that's sly as a fox. Anyway, they pointed out that Solis testified he feigned his interest in the state job board. Part of his undercover work in a secretly recorded June 2019 conversation, Solis also asked an uncertain property developer named Andy Krettel if there would be any possibility for Madigan to get legal work from his company ZOM Living, Union West Apartment Complex Anyway, the prosecutors went on and countered that Madigan had plenty of chances to walk away from the dealings of Solis, especially after the 2017 incident, when in another conversation, Solis implied that the Union West developers understood development works via a quid pro quo arrangement. Madigan also continued helping Solis find a state board job back in 2018, even and after Solis told the then speaker, "I'll continue to get you legal business." Use your common sense here, ladies and gentlemen, the prosecutors argued. They told the jurors in his rebuttal closing. The jury received the case after a 55-day trial, listening to at least 6 days of closing arguments, and there were at least 60 witnesses who testified in the trial. Now, throughout most of the trial, there were no proceedings on Friday, but after the jury began deliberating, they sent a note to the judge and said, "Oh yeah, we're coming in on Friday." The judge noted, "Hey, that's the best jury ever." Now, imagine that, ladies and gentlemen. I thought people went into public service to do their public service, not to get work for their law firms, not to get work for their buddies. I've been this naive all along to think that people go into public service for the exorbitant pay. I mean, it must be interesting. A lot of them go in quite poor and come out quite wealthy. You almost got to wonder why politicians aren't required to show any sources of income other than their legislative salaries, isn't it now? Could be illegal. Could be illegal. Next on the docket, this day in legal history, big day, January 31st, 1865. Congress passed the 13th Amendment to the Constitution, abolishing slavery. And then on January 31st, 2020, the United States declared a public health emergency in response to COVID-19. Needless to say, we all remember where that went, didn't we? And then on January 31st, 2011, a federal judge in Florida ruled that the Patient Protection, also known as the Affordable Care Act, was unconstitutional due to the individual mandate. Needless to say, that didn't stand up. It went all the way to the Supreme Court. And based upon a plurality decision, it said that the government could make you buy health insurance or fine you by imposing a tax on you. We'll just leave it there. And finally today, our dumb criminal of the day. A young manager of a Wingstop location is facing felony charges after she threw some hot grease and some ranch dressing at a customer during a verbal confrontation. The whole thing started when the accused, Carmel Irene, was a worker at a Wingstop location in Port St. Lucie, Florida. Anyway, Irene told police that the customers, one of whom is a minor, were loud and disruptive, and they were causing a disturbance. During the dispute, which is not really a whole lot of detail is given, but at some point the conversation escalated when Irene responded by throwing ranch dressing at the victims after one of the subjects threw some straws on the floor. Then Irene goes back into the kitchen area, returns with a bucket of hot grease and threw the grease on the victims. And guess what? It was backed up by the store security footage, and when the police arrived, they noticed that people had tried to clean up the liquid. And they also found the bucket. Anyway, the manager tried to justify her actions by stating that the customers were being verbally abusive and had reached over the counter and knocked over the straws. Well, needless to say, the hot oil recipients complained that the liquid burned them. Ouch, it hurt. And apparently they had some burnt skin. Can you say huge lawsuit? That's right. Anyway, when the cops arrived, guess who got arrested? Miss Irene. She was arrested and charged with aggravated battery and aggravated child abuse since one was a minor, all felonies. She was released on a $15,000 bond. Irene, don't. I don't think you will ever do it again. Don't go back and get some hot grease and throw it at anybody. But remember, if it's verbal, you got to keep it verbal. It doesn't allow you to get it physical in the argument. Just throwing that out there. Anyway, Irene, you are a dumb criminal of the day for letting your emotions get the best of you and escalating this entire incident. And now you are the one that is going to have to pay for it. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. Enjoy the weekend. And remember, the Constitution matters.